Thank you for joining us for another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into Nevada's judicial education. I'm Anne-Marie Mayu, your host.
And I'm Seth Beasley, your co-host, proudly representing the Supreme Court of Nevada Administrative Office of the Court's Judicial Branch Training Unit.
Today, we delve into a highly relevant topic, recent decisions in water law. Seth, would you please introduce our esteemed guest who's going to shed some light on this discussion?
Absolutely. So joining us today is none other than Nevada Supreme Court Justice Patricia Lee. It is our distinct privilege to welcome her to the studio. Thank you very much for being here, Justice Lee.
Thank you for having me, guys.
Let's jump right into it.
Okay.
So let's delve a little bit into the core holdings of the Sullivan case. Could you elaborate a bit on the significance and implications of the ruling regarding the state engineer's authority to conjunctively manage surface and groundwater?
Absolutely. And thanks again for allowing me to have this platform to talk about this case and the broader implications for water in our state, as it is a very precious resource. And we have to make sure that we are doing the right thing for our constituents in our state. So just to be clear on your question, Justice Pickering had already kind of established precedent for the court on the conjunctive management issue. And that was in her decision in Eureka County versus state engineer. And that citation, for anyone who cares to look it up, is 131 Nevada 846. And that was in 2015. And in that case, the court's holding took into account that groundwater appropriations would cause springs that source existing rights to cease to flow. So we just didn't use the words, quote, conjunctive management, end quote, in that case. But it's pretty clear that we already used the concept in our prior case law. And then the legislature gave us a policy directive in the statute to interpret the statutes in line with conjunctive management. So I'm not sure that the conjunctive management holding was truly that significant.
Okay.
So the Sullivan case, which is the case that you really do want to focus on, I believe, although it has a lot of different other statutes attached to it, it addressed the state engineer's ability to administer multiple basins, even combining them into a super basin. That's correct?
That is correct.
Okay.
Yeah.
So can you kind of share with us this discussion and the implications for water resource management across different geographical areas?
Yeah, so I think for me anyway, the joint administration holding is a bit more significant than the conjunctive management, since we'd already kind of touched upon that in the Eureka County case. And it wasn't clear that our legal theories had kept pace with the scientific theories. So it's fair to say that we recognize that groundwater does not necessarily follow topographical basins, such as mountain ranges, hills, valleys. So groundwater supply can stretch across a huge area, which is pretty much our state. It's Nevada, right? Where we just don't have enough water for every use. So when you have multiple water users in this giant area, all taking from the same source of supply, someone isn't going to get as much water as they want. So the challenge for us was to recognize that rights can be impacted across surface boundary lines. And once we recognized that, it was clear that the prior appropriation doctrine did not care about arbitrary lines on the ground, and that the legislature wanted us to interpret the statutes in line with the best available science. And so we did. And then in determining the amount of unappropriated water in what we were calling the LWRFS, which is an acronym for Lower White River Flow System, which is also known as the Carbonate Rock Aquifer System. This took me a few days just to get the terminology down.
Right.
But, so in determining the amount of unappropriated water in the LWRFS and in accounting for the impact on the source of water, the state engineer had the implied authority to conjunctively manage the surface and the groundwater and to jointly administer across multiple basins based on the interconnected source of water that flows to vested rights holders. And so we don't really know the full scope of the implication of this holding at this point, but it's fair to say that the state engineer has a new tool in his toolbox. And the court, we anticipate that we'll have some new cases that we may have an opportunity to interpret the state engineer's authority in ways that benefit specific water right holders. There's some indication that the state engineer had already jointly administered some areas in Nevada, and the issue just never, it just never made its way to us. So even on this issue, I'm not sure just how significant the holding is at this point. We'll have to see what, new cases the court gets in the years to come. And I'm sure there'll be quite a bit.
So when you talk about, other cases that may have reviewed this, but they didn't make its way to you in the Supreme Court, is it because no one really questioned the decisions? Is that they didn't appeal the decisions at a district court level? Right.
It wouldn't have been appealed to us. Okay. So, yeah, because unless they bring it to us, we can't intervene or rule. So, yeah, it just had never made its way up on that issue.
Okay, so we have kind of touched a little bit already on precedent. You mentioned the ruling of Justice Pickering, was it?
In the Uric accounting case?
Yeah. Do you have anything else to add about that existing legal precedent? And also, were there any statutes that existed to help determine the state engineer's authority?
Yeah, well, we cite to some precedent that's kind of relevant, adjacent, right, to what we're doing here. But because this is a kind of a new edict that we have ruled out, there's nothing exactly on point. Like I said, Eureka County was probably the closest one in the sense that it did discuss what we're now calling, conjunctive management. But other than that, we heavily relied on the statutes that were promulgated by the legislature. And there were a lot of statutes in the Sullivan case. So, we had to think of everything from pre-statutory vested rights, which were afforded protection under NRS 533-085, which the Muddy River Decree falls under. And because those rights, by the way, were appropriated before 1913, which is how we define pre-statutory vested rights. And under NRS 533-085, the state engineer is prohibited from impairing the rights of vested water right holders, and that's regardless of the source of water. So in order to protect pre-statutory vested rights from impairment, the state engineer must be able to determine the extent of the groundwater, resource that feeds the Muddy River, to determine which users are pumping and how much they're pumping. And then the state engineer must then have the authority to determine the maximum amount that can be pumped from the aquifer or the LWRFS as a whole in order to determine whether water is available for further appropriation and to protect the flow of water to senior vested rights holders. So there was quite a bit of statutory interpretation going on in the opinion. We use just, basic statutory interpretation tools for the most part. And we do have quite a bit of case law that says how we are supposed to interpret statutes. And so there's a couple of principles that underlie the opinion. The first is that we paid a bit more attention to the prior appropriation doctrine when interpreting statutory authority. That's just basically a prior use doctrine. If you used it first for beneficial purposes, then you have rights that precede subsequent users. The second thing is that we also interpreted statutory authority in line with the legislative policy directive that tells the state engineer to use the best available science. So slightly unique to this opinion is that the prior appropriation doctrine provided a backdrop for our statutory interpretation. And since we were concerned about the potential impact on senior vested rights, which, while not carved into the statutes, were originally creatures of, which are now carved into the statutes, but those were originally creatures of the prior appropriation doctrine. So I suspect that future decisions that impact senior vested rights may pay a bit more attention to the prior appropriation doctrine. So And I think it's fair to say that while the law will always lag behind science, we're going to pay attention. Yeah, we're going to pay attention to legislative policy directives in statute that tell us the state engineers to use the best available science. So part of the decision was in light of the reality of the world, right? In other words, the legal interpretation had to make sense in light of the reality that sources of supply do not care about the artificial lines that we draw on a map. More than anything else, we just wanted the opinion to make sense. So hopefully it did.
Well, so for our audience, can you kind of define what we talk about when we talk about vested rights? What are those?
So there's pre-statutory vested rights, meaning anybody who acquired those rights prior to 1913. And those are superior to all other subsequent right holders. So you have your pre-statutory vested rights. Again, those existed under common law prior to 1913. Okay. And our statutes say you cannot impair those rights by statute, by subsequently implemented statutes. And then second, then there's everyone else's rights. So those are statutorily granted rights, which include permitted and certificated rights. And so those are the subsequent users of the water in any given source. So it's just a priority statute, right? So that's kind of the hallmark of the prior appropriations doctrine. So,
and is there a difference between, because you use the term senior vested rights?
Yeah, so those would be the same as the pre-statutory.
Okay.
Pre-statutory, yeah. So they're referred to by both senior, right, because they're senior to everybody else. Okay. And the reason why they are senior to everybody else, so senior just denotes kind of the position that they have, is because they are a pre-statutory vested water right holder. Right. The Muddy River is, in fact, it's cabined in a doctrine, Muddy River Decree. It was pre-1913, and so there's no subsequent water right holder that can impair the rights of the Muddy River who has senior rights because of when they vested.
Okay. So it sounds like there were some significant challenges around the Sullivan case, and anyone living in Nevada right now knows that the water law it's a big deal. There's been some changes through the legislature on it. We know that in judicial education because we were called to up our game on water law education and develop some specific water law judges who were certified for that. Right. So we're very well aware that it's an important piece to living here in Nevada. Can you name some of the challenges that were addressed within the legal framework?
Yeah, I think, just one of the most significant challenges, I think, for my chambers was just how large this case was. There were thousands of pages of appendices of the record and hundreds of pages of briefing. And much of the record was not only legally rigorous, but also technically and scientifically difficult. I was psychology and communications major as an undergrad.
Right.
And so I think I took one geology course that touched a little bit about topography and things of that nature. But, it really was scientifically challenging for the lay person to try to figure out kind of what had gone on, what the goal of the state engineer was, understanding the stress test on the pumps that were done and what it showed. And that really these artificial lines that we've drawn and with demarking these separate basins really didn't fit with the science that, if you pumped from one basin, it affected others significantly because they all share the same source of groundwater. So we spent a significant amount of time making sure we understood the scientific theory behind water movement and how drawdown at a distant well could possibly affect a spring miles away. And then how we addressed it. Well, I mean, you can see how, and how we addressed it in the opinion, but right. And one of the unmentioned challenges was that we were aware that the audience for this opinion would include quite a few non-lawyers and perhaps even non-scientific people who, much like myself, would not readily understand kind of this complex area. So the opinion, I think we really try to write it in a way that we hope members of the public will understand. That was really important to us.
That's great. That is important.
While we pause for a quick break, I'd like to extend a special invitation to our listeners. Alalo Nevada goes beyond just being a certified legal education podcast. It's crafted with inclusivity in mind, welcoming all who are interested. Our goal is to foster connections with communities and offer valuable insights into the Nevada judiciary. If you found our episodes engaging, we encourage you to spread the word and share this experience with your friends and family. Your support is greatly appreciated. So, to what extent does the Sullivan case promote collaborative governance models in water resource management, particularly in the context of joint administration of multiple basins? And how can such collaborative approaches enhance efficiency and effectiveness in water management?
So, I'm not sure we know the answer to that question yet.
Fair.
So, from the court's point of view, in Sullivan, I don't think that we addressed governmental agencies collaborating to jointly administer water resources in that respect. Really, our opinion was just really cabined to the authority of the reach and scope of the authority of the state engineer. And so the two most important things I think that came out of Sullivan is that we held that the state engineer, based on the statutes and based on our prior case law, and based on the science, was able to jointly administer all of the subbasins and to conjunctively manage the groundwater and the surface water. So obviously, we hope that people can come to a collaborative agreement outside of court. You know, I think that we have some other things going on with the Colorado River Compact and our sister states and how we are all trying to allocate that water in a fair and equitable way, and so that all states can benefit from the limited resources that we have. And so, but that I think goes well beyond kind of the limited scope of our holding in Sullivan.
Well, I think that's all very true. And I have a feeling with, this new designation of water law judges, district court judges, you're going to probably see more and more cases, which is good and bad. It's good just simply because then it gives you a little bit of meat, a little something to look back on and be able to help make the decisions going forward. So how can the core holdings of the Sullivan case serve as educational resources for Nevada judges seeking to deepen their understanding of water law and its practical applications in judicial decision-making?
I think the tough part about Sullivan was just like the sheer number of statutes, right? And the arguments made by multiple parties. So this is a huge piece of litigation by anyone's standard or definition.
Right.
And the number of statutes that were relied upon is in some ways very appropriate because the state engineer and his authority is created by statute. But it does make it difficult for the judiciary because the parties at times blend their statutory arguments in ways that, frankly, are not persuasive or do little more than confuse the issue. So I think for judges, they just need to independently look up the language of the statutes and check to see what our case law says on the issue, assuming we have case law on the issue. If not, let the statute be your guide. The other thing to be aware of is that most of Nevada is dry. And so, there's this notion of certainty of right? Certainty of right, which is really the reason why we continue to uphold the prior appropriation doctrine. There just isn't enough water for every use throughout the state. So we have to decide somehow who wins and who loses. But judges should keep in mind that the prior appropriation doctrine is a holistic theory. We're probably not going to segment like a river from a stream or a stream from a spring or a spring from groundwater unless the legislature is pretty clear that's their intention. So that's part of the underpinning of Sullivan really is that, the certainty of right just does not care where or how distant the source of supply is relative to the appropriation. And so, and I'm very happy and proud that retired Justice Hardesty and Justice Perigary did create kind of this niche water law space and education for the judiciary, because it's not an intuitive, easy area of law, because it's so commingled with the science, and so many different statutes have to be read harmoniously. And it's a painful piecing together of a puzzle in some ways to try to figure out where the limits of the state engineer's authority lies. And then, this case still continues to march on, obviously. I can't talk about, whatever's going on down below, is that I don't even know what's going on down below, but I wouldn't be surprised if we saw this case back up for different reasons as this case continues to progress. And, unfortunately, we are making this law as we go along, or I should say interpreting this law as we go along. And so we can only address the issues that come up before us. So, I think there's a lot of value in taking these types of cases up where we have the dearth of case law to address these new challenges.
Yeah, I agree.
All right. So before we wrap up this discussion, is there anything else you would like to share with our audience on this case, or just anything else you'd like to add regarding water law in this case?
Well, I would encourage everyone to read the opinion. Make sure to have a cup of coffee or something caffeinated, because, it is not it's not a short read. And I do apologize for its late, but we really did feel that it was necessary to kind of lay out step by step our thinking. We wanted to think out loud and show, what we were thinking about as we move through these analyses. And we wrote it with the members and the public in mind. Like, we wanted it to be understandable to anyone who was interested in the state of our water, at least to the extent that it was addressed in the appeal. And so like I said, I would just kind of encourage everyone to read the case, share it with your colleagues, particularly if you are on the bench and interested in doing water law. I think it gives a good kind of foundational background of where we've been, what has happened, and what we did in response to that. So, and that's just the tip of the iceberg in terms of what there is to know about water law. And I do not profess to be any type of water law expert at all. I got, kind of brushed up on and educated for the purposes of writing this opinion. But now that I have, it's an important and, very germane topic that is going to continue to impact our state and other states that have the same deficiency in resources as we do. And so it's something to just kind of keep an eye on, I would say.
Well, I think what we'll certainly do is make sure that our listeners have access to that opinion so that they can access it easily and read up on it. And I will have to say that the length and thoroughness just speaks to the importance of the topic. So thank you.
Thank you, Anne-Marie. I agree. So while I apologize for anyone who has to read it,
right.
I think you're absolutely right that it was a necessary evil.
Yeah. Sounds like a lot of care was taken to make it readable to like you said, a layperson, someone who doesn't necessarily know that much about topography or something that your average person could read.
Right. You can read it in digestible chunks. Just
yes.
Like a good book. Like a good book. Yeah, just have it on the nightstand and read it before bed.
Or maybe we'll do the audio version of the opinions.
There you go. Well, there you go.
An audio book, just read it. Oh.
Yeah, the audio opinion. That could be a new thing.
Sure.
Well, Justice Lee, thank you very much for taking the time out of your busy schedule to speak with us regarding the Sullivan case. It's been really interesting, really fascinating to hear you speak about it. So just thank you very much for that.
Well, thank you guys so much for having me. I really enjoyed it. And I'm just very happy to talk to your listeners about this very important subject. So thank you again for having me.
A heartfelt appreciation to our guests and as well to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released every first and third Friday of the month. This is Seth Beasley signing off. Take care, Nevada.